Good afternoon. I'm here today to testify that Fairfax County government absolutely has the authority to enact a local living wage ordinance that applies to government procurement contracts if the county concludes that doing so would improve the quality of the goods and services procured. Now, Virginia is one of the few Dillon Rule states in the Union, which means that local governments like Fairfax County only have the powers that are specifically granted to them. So, for Fairfax County to have the power to enact a living wage ordinance, somehow the state legislature must have granted Fairfax County that power. Well, in 1982, the state legislature enacted the Virginia Public Procurement Act, which explicitly states that when drafting procurement contracts, county governments can incorporate best value concepts. And best value is defined in the statute to include things like quality. And the procurement contract also states that when drafting procurement contracts, the county governments have to pursue competition to a maximum degree. So, from a legal standpoint, the only way Fairfax County can enact a living wage ordinance is if that ordinance would result in improving, or is designed to result in improving, the quality of goods and services being procured and is consistent with the pursuit of competition. And as other people have testified here far more comprehensively than I can, there's no question that a living wage ordinance would result in higher quality goods and services for the residents and taxpayers of Fairfax County. Even President Bush hiked the salaries of airport security workers after 9/11. Why? Because he wanted to improve the quality of airport security. And the same logic applies here in Fairfax County. A living wage would result in higher quality goods and services. But the remaining question is, would such an ordinance be consistent with the pursuit of competition? Otherwise, it's not legal. And the answer to the question, unequivocally, is yes. It is consistent with the pursuit of competition. The opinions of the State Attorney General, the rulings of local and regional courts all define competition in a procurement context to mean that any contractor can bid on the contract. Any contractor. And then the bid is awarded to the lowest responsible bidder. Well, a living wage ordinance would allow any contractor to bid. Any contractor could bid. It doesn't matter if you've paid your employees horrifically for 50 years. It doesn't matter if you paid your employees spectacularly for 50 years. Every contractor could bid on the contract. And then the contract is awarded to the lowest responsible bidder who's willing to pay their employees, a living wage for the work performed under that contract. So there's no question that a living wage ordinance is consistent with the pursuit of competition. There's no question that a living wage ordinance would result in higher quality goods and services for the people of Fairfax County. And therefore, there's no question that Fairfax County government has the authority to enact a living wage ordinance that's narrowly tailored to government procurement contracts. And if there's any remaining doubt as to whether or not the county has that authority, that doubt has to be dispelled by recent events in Richmond. Over the past 6 years, 3 municipalities, as Mr. Zimmerman mentioned, have enacted living wage ordinances. Alexandria in 2000, Charlottesville in 2001, and Arlington County in 2003. And this resulted in a bunch of lawmakers in Richmond proposing legislation to prohibit local governments from enacting living wage ordinances. But all 4 bills were soundly defeated. All 4 bills. And when one bill made it to the Senate floor, the only one that made the Senate floor, Republican Senator Thomas Norman, I believe, said we should not be micromanaging local government affairs. Democratic Senator Craig Deeds said these are issues best left in the hands of local government. So it is quite clear that the state legislature has implicitly and at times explicitly granted local governments in Virginia the authority to enact a living wage ordinance that would apply to government procurement contracts. All that's left is for Fairfax County to have the political will to do so that the residents of Fairfax County can have high quality goods and services, and so that we can help lift hardworking families in this county out of poverty. Thank you.
Just a question. May I ask a question before you sit down? My great faith in the General Assembly and their ability or their desire to give local governments the right to attend to their own business. I would like to find out whether the reason, Mr. Norman, and knowing Mr. Crades, is that they felt that the Procurement Act as it stands and approved by the General Assembly and granted to the local government was indeed the piece that gave us that authority and granted in that procurement law.
If I understand your question correctly, Supervisor Hutchins, did they not prohibit the enaction of local living wage ordinances because they thought the Procurement Act itself already provided that power? I believe so.
Yes.
Yeah, I believe so. There was a State Attorney General opinion that came out very controversial opinion that said, no, you actually don't have that power, which worried a lot of people. The law was already on the books in Alexandria, already on the books in Wilmington, already on the books in Charlottesville. But with all due respect to the State Attorney General who drafted the law, it's a false interpretation, and it's premised on one assumption. He says you can't pass a living wage ordinance for moral purposes. You don't have that power. You can't pass a living wage ordinance if your fundamental intention is just to lift people out of poverty. You don't have that power. But he did not make the next step. He did not say the living wage ordinance could result in higher quality goods and services. He did not make that next step. He agreed that if they would result in higher quality goods and services, you would have that power. But it didn't even occur to the State Attorney General in his opinion that it was conceivable that living wage could result in higher quality goods and services. So if the bill is designed, and I think Senator Thomas Norman and Senator Craig Deeds were aware of this, if the bill is designed with a partial intention to improve the quality of goods and services, I think there's no question that you have that power. And that it also results in lifting working families out of poverty is wonderful and a positive incidental value of that legislation. I hope that answers your question.
Very much.